can I have everybody's attention, please? Dennis?
Yes.
Thank you for coming. You're welcome. Thank you everybody for coming to today's presentation on advocating for relative placement. Today it's being presented by Jennifer McCartney from the Children's Law Center and Cecilia Woodard, formerly of the Children's Law Center, and currently with LADL 5. Just a note that a lot of the information that's being presented to you will probably be repeated and honed onto you in a future training on detentions, which our own Dennis Smith will be doing hopefully very, very soon. This is a really important aspect of, I think, representing parents and ensuring that their children are in a place that the parents want. So without further ado, please.
I'm a CLP1 supervising attorney, and we have presented on relative placement before. If you're wondering why it's important for you guys, the main issue that I want you to take away from this is that, especially for Parents Council, in almost all of the appeals, when it gets to a 2-6 hearing, the Court of Appeal has said that parents don't have standing to raise the issue of relative placement. So it's essential for Parents Council to raise the issue as soon as possible, aka detention, to get the process going if you want your client's child to be placed with a relative. So let's get into what's a relative. So a relative is entitled to preferential consideration for placement, and that's an adult related to the child by blood, adoption, affinity within the 5th degree of kinship or consanguinity, if you all remember that from law school. So that includes step-parents, step-siblings, any relative that was preceded by great or great-great or grand, or the spouses of these people, whether or not they're divorced, the spouse that's actually the blood relative has passed away. So even if, you know, Aunt Jane was married to Tom and Aunt Jane passed away, Tom is still considered a relative under the relative placement considerations. Preferential consideration is a specific legal term basically meaning not that for sure this is happening, it's we're just going to look at this person first. They get the first bite at the apple for placement. Effective January 1st of 2018, preferential consideration no longer is limited to grandparents, aunts, uncles, and siblings. It's any relative. The previous language before that in the code section had specified that only those designated relatives would qualify for the preferential treatment for relative preference, and through some craftiness when we were working on language for relative placement, we actually got that language taken out of the code section. So the other preference that goes into it is a non-related extended family member, or NRFM, as we're all familiar with. How to establish who is a NRFM under the law is someone that has an established familial relationship with the relative of a child, or a familial or mentoring relationship with the child themselves. So a teacher, someone that's like a mentor to the child, or a caregiver from like the daycare that they normally attend could qualify as a non-related extended family member. Or even, I don't know what this is called here, but like a calabash cousin or whatnot, or like it's mom's best friend who normally like hangs out with the family and they have an established relationship prior to detention. Any questions on that? The other preference that's in the code, which hopefully you guys are seeing Writers Council is working on, is the sibling preference. So the code specifically states when siblings have been removed from their home, either as a group or in separate occurrences, that the siblings will be placed together unless it's been determined by the court that placement together would be contrary to the safety and well-being of any of the sibling group. All right, so the citations at the bottom of the slide for if you guys want to know where this comes from and if you want to cite to it when you're making your arguments. So the benefits of relative placement. So in general, what kind of benefits do children receive from relative placement? And looking at it, it's generally less traumatic because the children are living with someone they know or familiar with. For whoever has a child or worked with children for a long time, kids don't in general like change. And so to make it less traumatic for the children, then they're with a familiar situation, maybe going to the same school, that kind of thing. So it also supports the transmission of the child's family identity, culture, and ethnicity. One of the things that we've all been taking at CLC, and I'm assuming at LADL, is cultural competence and making sure that children are being addressed in their cultural heritage and that that is being respected and treated well. And so placed with relatives normally ensures that the child is still being raised in that environment. It also eliminates the unfortunate stigma of children being in foster care. So one of the big issues that CLC had before is that social workers would go and see foster children at school, letting the whole school basically know that they're in foster care, which once you're told you're in foster care, you have to explain why you're in foster care, which most kids don't want to discuss openly amongst their peer groups. I mean, in general, kids can be harsh enough not to add one more thing to these kids' plates. Again, it reinforces the child's sense of identity, self-esteem, and that all comes from family history and being in their culture. Children placed with relative knows his or her family, sees the family resemblance, understands who he or she is, and where they fit into that family. As many of you probably know, foster and adopted children in general tend to search out their families when they're old enough, have questions, sometimes even make up of like what they think their biological family is like, and they don't need to do those things when they have a connection and are placed with relatives. Data indicates that foster children living with relatives experience abuse and neglect at lower rates than children with unrelated foster families, and that's a really big thing. We want, obviously, these kids to be as safe as possible if they have to be in out-of-home care, and just statistically, they are being treated better while they're in relative care. Generally, they also have fewer moves as opposed to the kids who you see bouncing between foster home to foster home to foster home, because the relatives usually have an investment in this child, they love this child, and they're trying to work with whatever behavioral issues that are coming up for the child. Children maintain their community connections, so being able to be in their schools, being able to still go down the street to other family members' houses and whatnot. They have that sense of community. Okay, so we're gonna get into yeah.
Just a quick question. Given that the code says that siblings will be placed in foster care together unless it has been determined that placement together is contrary, contrary to the safety or well-being of the sibling, what if the department's response is, well, we don't have foster parents that have room to keep the children together? As I'm sure Minors Council has a position and argument, as LADL Council, what would you recommend would be effective to help bolster any arguments to keep them together?
I would first indicate that the department provide evidence that they've actually tried to find all of these placement. We actually were on a recent call on like stakeholders and whatnot, and the department disclosed that there was multitudes of empty RFA approved foster homes because you know, for the most part, social workers have go-to placements that they know from all of their years of experience, and so those are the ones that they hit up first, or the FFAs. And so there was standing empty RFA approved foster homes. And most of the time when you put the department's feet to the fire as to, okay, so you've tried Olive Crest FFA, well, what about Serenity? What about this? What about that? Like, what placements have you tried? As we all know, foster care is an ebb and flow. There's sometimes a bunch of kids that are going to be in care, and then if not, then there's openings every other day, depending on what kind of level of care the child needs. So A, I'd start with putting their feet to the fire that they actually have exhausted all the resources for placement. And B, I would say, so what are you doing to find relatives who could take all of these kids? Because one of the things that I think, although LA County is so much better in relative placement in some ways to other counties, we really do not do a good job of 309E, which is doing a due diligent effort to find the relatives at the beginning of the case. I mean, most of you have heard at like an RPP where the kid's like 17 and they're trying to find a relative and doing family finding then. That's a tad late in the game to be getting relatives involved in this child's life. And one of the things that I think is very problematic is like the shame that's involved in foster care. A lot of parents don't want to tell their family like, my kid's in foster care. I've heard it many times, often at a 2-6 when the grandparents are showing up for the first time going, I had no idea, they said this and they said that, or we lived out of state, we had no idea what was going on. That's something I would love for you guys all to work on with your clients, because the shame is a 2-second moment. Your family loves you, sometimes they give you grief even when you're doing everything right. The lasting impression for that child, if they're going to be adopted out of that family and never see their family again, is completely a possibility if relatives don't come forward at the beginning of the case, or even are visiting throughout the case. So say there's a criminal waiver that needs to be had for grandpa or whatnot. If grandpa has no visits while we're waiting for that waiver, that relationship is dwindling versus the child is placed with a non-related foster parent who wants to adopt, and it's going to be harder the longer it goes to do that separation if the grandpa has no real relationship with the child by the time you get to the 2-1F.
What's the mechanism of holding the department's feet to the fire and showing like that they've been making diligent efforts to place the siblings together? Is it a relative placement hearing, or how would you recommend we go about doing that? Like, what type of hearing are we requesting?
So I think it depends on when you bring up relative placement. If you're doing it at detention, I would highly suggest saying to the court, Your Honor, and if there's no relatives that are there, Your Honor, there's a requirement under 309E that the department make a diligent effort to locate relatives. I'm asking that the report for the next hearing specifically address which relatives and how they noticed them, and what efforts that they made to actually locate them. I mean, in this day and age, let's be honest, like, you could probably just put a blast on social media for like mom or dad and figure out like 1 million relatives who would be able to take these kids. So what efforts the department made? I mean, at minimum, they're supposed to be asking mom and dad, like, do you have relatives? Do you have anyone available? And then they're supposed to notice them and tell them that these children are in foster care. Do you want to have contact? Do you want to have care of these children? And when you get the report, if the report doesn't address that and the court ordered it, ask for an OSC. That's a direct violation of the court's order. And so you can ask for the department to have an order to show cause as to why they didn't follow the court's direct order. I think the biggest problem that we have overall is that when you're in the scuffle of the normal day of court and you're worrying about whether or not the petition's going to get sustained and all these things and what's the rec for dispo and your client's yelling in your ear, everyone forgets about relative placement unless there's a relative going, I want placement. And that's the biggest problem because a lot of relatives don't even know to come to court. And so that family finding, even if it's like putting a post-it note on like your court appearance sheet for the next hearing saying relative placement, they were supposed to like address it so that you can have a reminder to yourself. Dennis?
But also, we need to be clear, at least, the attorneys in my firm, need to be clear that it's your job at detention to be finding these relatives. It's your job to be asking at least 20 questions of your client and identifying any relatives. And if they don't have complete information, then providing the department with that information on the record at the detention hearing. Then you're going to have something to hold their feet to the fire about, because I gave you everything but her phone number. Why haven't you lifted a finger to place these kids with her? So you've got to understand the barriers to them telling you that, as Jennifer pointed out, yes, it is shameful. The last thing you want to, and again, keep in mind, grandparents have usually been dealing with the problems that we're here for the first time dealing with at detention for years. So they've been telling their kids, the parents in the case, for years, you're going to get your kids taken away if you don't stop using drugs. This is going to happen, that's going to happen, and the last thing the parents want to do is call up grandma and say, yeah, you were right. So you've got to tell them a horror story. And it's not easy to tell that horror story until you've actually lived through it yourself. But when you've had a grandma who didn't know that her kid was detained until 6 months down the line, and then did everything in her power to get the kid placed with her, and then you're the one who's trying to comfort her when her grandkid is being placed for adoption. Until you have that story, it's hard to tell the horror story, but tell the horror story anyway. There are plenty of people here who can tell you what it was like.
And I would also, that's fine. I would also say it's really important to also discuss with the parent, like, we've seen it, where the referral comes in because grandma narked on what happened. Like, she said that, like, even if it says it's an anonymous reporter, most of the time we can figure out who it is. So even if that's the situation, hey, I understand you're really upset with your mom about this, but she has a house that can take the kids, and she loves you at the bottom line of things. It's better for the kids to be with her, and you can have more access to them than potentially like in foster care, where they're not going to let you at their house for the most part. And so it's really important to get into the weeds with them sometimes about those kinds of issues. Oh, repeating the question. Okay. I don't remember what the question was. I'll be honest. So we're going to get into the specific hearings now. So prior to detention, leading up to detention, Welfare and Institutions Code Section 309 is what we go to. So if a child is taken into temporary custody, the social worker shall immediately release the child to the custody of the child's parent, guardian, or relative. So if there's an appropriate relative, they can immediately release the child. Obviously, you've seen it where the petition comes in and the child's already placed with the relative. That is what they're supposed to do. They have 72 hours to investigate those relative placement options. And so if your client's coming in and telling you, hey, my mom was literally there when they were taking the kids and she was offering to take the children, that is something that should be brought to the court's attention, that the department failed to do their duty to assess the grandmother and basically told her to come to court, which we've heard many a times. So they have a duty to assess under 361.4 temporary placement or emergency placement with a relative. And so for that, it's just a CLETS or a live scan, whichever quicker. Normally it's a CLETS, a khaki, and a walkthrough of the home. Not a full-on inspection of the home, not an RFA approval, just a walkthrough on, do you have smoke detectors? Do you have somewhere for this kid to sleep? And even if they don't have somewhere for the kid to sleep, that they're gonna get one, or there's access to that. And if they have a clear CLETS and khaki. So it's very simple. It doesn't take a whole lot of energy. When CLETSs are clean, they come back within minutes most of the time. And so it's not a long process that the department has to go. Their preference is to do RFA, which you all know is like a 6 to 9 month process. Kids would never get placed with their relatives if we just waited for RFA every time. So the duty under 309E is within 30 days, the social worker shall use due diligence to identify and locate relatives and shall provide all relatives notice that the child has been removed from the parents and options to participate in care or placement.
Just real quick, back to the walkthrough.
Yeah.
Is there a place like a DCFS policy or some type of guideline that the department is, I guess some type of list the department is checking off when they're doing the walkthrough? Because I think many times we'll see, let's say a PRI or something come in and they'll say, oh, they're missing A, B, C, and D, or they have a pit bull that's may have access to the inside of the house, so therefore we can't approve the home. Is there anything that
The home doesn't need to be approved. Oh,
No, just
sorry.
in this case,
Is
the
there, I'm repeating the question. Is there a specific list that indicates what was required for a walkthrough of the home? There's DCFS policies that talk about what they're looking for, but the code sections only simply require that you do a safety walkthrough on basic safety precautions. So that smoke detector, now carbon monoxide alarm, I think that's what they're called, and that like medication isn't like strewn about the counter, that it's somewhere safe that the child can't access, that there's entry and exit ways that the child can safely walk out, because you know there's sometimes those homes that they added on a room or whatnot and you have to go through a room to get to a room and whatnot. Those are all things that you can apply for a waiver for when they get into the weeds of approving it. The walkthrough is just supposed to be a simple walkthrough to determine if the bare minimum safety requirements are met, which is smoke detector, carbon monoxide detector, there's a lock on the door, there's running water, there's, I don't know if you technically need heat here, most of the time.
Like electric, gas, or whatever.
But like you have working utilities and there's somewhere for the kid to go. Like if it's a studio apartment and there's like no bed, there's no nothing, there's like 12 people living in it, that's obviously going to be a safety concern that probably needs a waiver, just from occupancy standards.
But I just want to say, you want to be careful. So when you get a PRI on calendar, this happened to me a few weeks ago, and the minors attorney said, oh, it's negative, it should go off, right? You need to read it closely. You need to make sure the klutz is attached, because in that case, there wasn't anything that actually required a criminal waiver. They said there were some safety concerns in the home, and it was nonsense. I don't even remember what it was now, but the court placed, after I pointed that out, and she did a closer reading of the document. So that's our obligation, because it was my client's position that he wanted the child with a relative who was willing to monitor his visits, who was willing to actually facilitate reunification. And so it's just really important that when, I know not all bench officers order PRIs, but that when we can get them on, that we do take it seriously.
I would also say specifically at a detention hearing, if there's a viable relative who you definitely need more information on just because they didn't do anything with that relative, ask for a quick turnaround. They have 72 hours to do that under their legal obligations before they even get to court. So them failing to do it when they're like, oh, we need like 2 weeks or a month to like assess them, ask the court to come back within 72 hours on it and have the same things, Klutz khaki walkthrough. You have to remember, every social worker's office, no matter how understaffed they are, have a duty worker. So the duty worker can go out and do the assessment if the social worker's too busy or whatnot, and they just have to do that walkthrough and then run the klutz and the khaki, which is on their computer. Additionally, I would say make sure that they actually attach the klutz with the results, and I'm assuming at some point you guys had a training on how to read that, Dennis? Yes, no, maybe?
My only question is it clean klutz, no convictions or no arrests?
No convictions, and that's where I'm going with it.
So the question was, if a clean klutz is no convictions or no arrests.
So no convictions, unless it's an arrest for something like murder. They got arrested for murder and there was no conviction, no disposition or whatnot. That they would require a little more intense interviewing and figuring out under Health and Safety Code 1522. But the only thing that counts are convictions. And that's why it's really important to look at the klutz and actually look if it's a conviction, because the department will flag it even if it's an arrest that's like 30 years ago for petty theft and there was no disposition. They're like, oh, we need a waiver. That's not true. And it's on you to actually look at that, because they'll write it in a report that you need a waiver and it's completely not true. You had your hand up?
Yeah, I just wanted to add on to what Cecilia was saying about the court making a specific placement order over the department's objection. So there is case law that, you know, because it's statutory, the court cannot make its own waiver of criminal convictions, but the court can absolutely place in a home that otherwise doesn't meet RFA approval. We had that situation recently in Department 424. The court placed with maternal grandma, even though there were like 6 adults living in a 1-bedroom trailer with black mold and exposed wiring. And the department took a writ on this, and the Court of Appeals shot that down in like 2 business hours. And it filed at 4 p.m. on Friday, the Court of Appeal rejected it at 10 a.m. on a Monday. So the court does have that authority.
So, repeating and summarizing, the court has the authority, with the exception of criminal conviction, to place over the department's objection. So if there's something they don't like about the house, or if there's a khaki hit, the court has to make an independent assessment of the safety of the child. The only thing that will get you reversed every time is if there is a criminal conviction and there's no waiver yet, because the court cannot override the department. It is the sole obligation of the department to provide a waiver or not. Getting in the weeds, if they refuse to do a waiver and whatnot, there's things you can do for that, but see me or Dennis after the show. Yes.
What if it's one of those convictions that down the line gets dismissed, whether it be because like they're expunged or something? Is that a case where it was like grandma was committed a prostitution like 30 years ago?
Mm-hmm.
So she's like, oh, but I got it expunged, but it kept showing up on like the clefs as a conviction.
Mm-hmm.
Like, how would we go about with those types of situations?
So the question was if a relative from like 30 years ago had a conviction but it was expunged from their record, does that still count towards a conviction for the assessment? So under the Health and Safety Code, expungements don't really count in child welfare issues. Even if they have the expungement, they still need to go through the waiver process, because it's the idea of that criminal act requires some showing of like reformed behavior. So a waiver is normally they have to submit 3 letters of reference, so showing basically like, I'm different from the person who committed this crime, blah, 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 blah. As well as depending on what the incident was. So like for a DUI, they might have to do show proof that they did some kind of course to rehabilitate, or they participated in AA or whatnot in order to get the waiver. So depending on what the actual conviction was for will depend on what you need the waiver for, but expungements do not negate the requirement for a waiver. Yes?
What about the parent's ability to make an appropriate plan? Let's say somebody has a criminal background and the department isn't willing to, let's say a waiver is pending. It's likely to be successful, but for whatever reason, maybe the social worker is in agreement with placement. How does that impact, are you aware of any authority that would prevent the parents from making an appropriate plan with a relative pending the execution of the waiver?
I think that, I don't think it's set, the issue is if, I really suck at that part, sorry guys. If there is a parent who wants to make an appropriate plan with a relative who has a conviction and they're waiting on a waiver and the department's not in agreement, how does that affect the situation? Can the parent have the child with the relative under an appropriate plan if the department's not in agreement? I don't think there's any direct case law on point to that issue. I know that there has been case law that specifically goes as to the 360A requirements and that they do not need to meet for a 360A legal guardianship. I don't know if there's any case law, I would have to get back to you, on the specific issue.
In terms of incarcerated parents, the ability to make an appropriate plan, but I just was wondering if there's an authority that you're aware of.
I'm not sure as to the issue of like a waiver on a relative on their appropriateness and whether or not that like trumps that. I know the specific issue on needing a waiver on a relative on a 360A, the Court of Appeals said they do not. Like you're bypassing disposition, we don't need the department's approval in order to do an appropriate plan or do a guardianship with that relative if they wouldn't have passed RFA or AFSA at the time. But for you're doing the 360A. I don't believe there's any case law on point, but I can get back to you as to whether or not it applies in appropriate plan cases. Most of the appropriate plan cases, it seems like the relatives that they identified as the person that the child is already placed with through the department half the time. And so It's been more on the legal issue of like, is that an appropriate, could the parent make that plan?
And I have encountered cases where I have a client in custody who says they really could make an appropriate plan with their parent who has stepped up and taken care of this child, but they opt to submit on detention because they want their parent to get funding, because they're not in a position to provide that funding. So I think that's also something that you can discuss with your client and let them make the decision of how they'd like to proceed, but I've had it both ways.
Okay, so some of the frequently asked questions on these topics. Can the social worker place with the relative before the detention hearing? Yes, under 309, they definitely can place with the relative and should. If there's a relative available, the department should be investigating them and placing with them if appropriate before the detention hearing. Does the social worker need to wait for a fingerprint clearance before the child can be detained with the relative? No. They simply need a CLETS, which is just run through the computer normally with name, date of birth. If they have a more common name, they'll need a social security number in order to run it. So like John Smith, there's probably more than like 20 that have the same birthday. So they need to narrow down the identification and make sure that it's the correct person, that there's no criminal hits. But you only need the CLETS, the CACI, and the home inspection in order to go forward. The social worker under the code section is supposed to do fingerprint clearances with the relative within 10 calendar days of the CLETS or 5 business days of making the emergency placement, whichever one is sooner. So if the relative gets placement and they're like, oh, they're telling me now I need a fingerprint, they do. What if the CLETS indicates that the person has a criminal history? I believe provided with you guys for the training, there was a list of the Department of Social Services non-exemptable offenses. So those are non-exemptable offenses. There's multitudes of different types of offenses, and these are for convictions. So there's non-exemptable pretty much under any circumstances. There is not exemptable for like 5 years after the conviction. There's all kinds of different multitudes of that. The department, I'd say 9 times out of 10, get it wrong as to what's a non-exemptable offense. They don't even look at their own list. Because when you actually go and pull the penal code section and whatnot, it is inaccurate and it is an exemptable offense. So make sure to actually look it up. And that's the other point with having the CLETS. You know what they were actually charged with or convicted of, what penal code section, and what year. Because remember, the law is an ever-changing, beautiful thing, and the penal code section, specifically I think in 288, there used to be, under penal code 288, it was like a peeping Tom like conviction, and now it's sex with a minor. So 288 from 1960 is not the same thing as 288, last week. And so it's really important to make sure if there is supposedly a non-exemptable offense that you actually look it up and make sure it's actually a non-exemptable offense before dismissing that relative for a possible placement. Additionally, a child cannot be placed if there is a non-exemptable conviction. It's been upheld multiple times with the Court of Appeal. A child can be placed for any other conviction once the exemption has been granted, and the exemption comes through the agency. Unless you have an ICWA case, then it can actually come through with some distinction from Department of Social Services as opposed to the just county agency. As of January 1st, 2018, a child, and this is a rare circumstance, I'm gonna just put that out there right now. A child can be placed pending an exemption, and this is a big if. The deputy director or director of county welfare department or his or her designee, so probably at minimum an ARA, determines that the placement is in the best interest of the child, and no one's objecting on the case. No party is objecting. So I think this is the rare circumstance if you have an older child with special needs and everyone agrees that grandma's appropriate and grandma's 30-year-old conviction for petty theft is not that big of a deal, and they're going to place the special needs child with grandma pending it. With all the ifs, ands, and whatnot, obviously it's unlikely to happen on a regular basis. But it is an option when you have a unique situation that you want to say to county council, who's probably unaware of the fact that this exists as the law, to, hey, can you call out on this? Like, I understand grandma's pending this exemption and whatnot, but like, this kid has really special needs, grandma knows how to take care of them, and I always throw in some funding aspects, so if the kid's in a group home, it's $15,000 less a month for the department to pay for. So can you call out on this, and can we move forward on this as a possibility for placement? Any questions on that? The detention hearing. So the governing code is WIC 319. If the child cannot be returned home, the court shall determine if there is a relative able and willing to care for the child. The relatives will be given preferential consideration for placement. Per 309, emergency placement and 361.4 assessment should be done for the relatives. The report must indicate whether the relatives are able and willing to take temporary custody of the child. The court shall consider the recommendations of the social worker based on the emergency placement 361.4 assessment prior to ordering that the child be placed with a relative or non-related extended family member. So the court has to consider it. But case law tells us the court needs to make an independent judgment and not just go, well, the department doesn't agree. The court needs to make a finding of why or why not, like, this would be appropriate. And it can't just be, well, the department doesn't like it. The court needs to make that independent assessment of, well, I see that, you know, grandpa has this 40-year-old conviction, but it's a really serious one, so I'm not okay with this or whatnot. In regards to family finding, court shall order parents to disclose to the social worker names, residence, and any identifying information for any possible relatives. So it would be very helpful if that is already ready to go, those lovely relative placement forms, so that we can get those ordered as soon as possible for relative placement to happen. Can the court still order a child to be placed with a relative if the county welfare agency completes an assessment pursuant to WIC 361.4, but is not recommending placement with the relative? Yes, 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 yes. Whether or not the county approves the relative's home is just one factor for the court to consider under WIC 361.3. The court must exercise its own discretion, and that's a citation to MCLE. And obviously, as we talked about before, the only exception to that is in regards to a criminal conviction that needs an exemption. Alright, detention to dispo, as I like to call the bewitching hours. So this time period is very important in regards to relative placement, because there's a continuing preferential consideration for relative placement. That's undisputed. So they still have an obligation to do emergency placements if it's possible, if the relative can take the child on an emergency basis. And they still do the assessment under 361.4. They do not need RFA to be approved before going forward. They have a continuing obligation to identify and locate relatives under 309. And why this isn't so important is because as soon as you get past dispo is where all of it goes kind of haywire. So at disposition, continuing preferential consideration for relatives under 361.3, and that's the assessment that the court goes through with all the enumerated factors are things to consider about whether or not it's appropriate to place with the relative. Per WIC 358.1, the report must address the appropriateness of any relative pursuant to these factors under 361.3. In Re AK says that the court does not have a sua sponte duty to set a 361.3 hearing. Somebody actually needs to request it. So unlike certain provisions of ICWA where it's a duty to the court as well as the department to address those issues at the hearing, 361.3 needs to be raised by a party in order for the court to address it. It's not reversible error if they are like, eh. It needs to be raised, and there needs to be subsequent appellate action if they fail to address it. So resource family approval, or RFA, for whoever is like old school like me, the new version of AFSA. And so relatives and non-related extended family members need to be assessed under that, but they can get placement on an emergency basis pending that RFA approval. And there can be specific placements based on a compelling reason pursuant to WIC 16519.5E. And then the court is supposed to, and I don't think I've ever heard a court make this finding, that the department has exercised due diligence in identifying and notifying relatives that the child is in foster care. So it's a requirement under the code if you're getting pushback about it. Just cite to the code section, and it's their obligation of the court to do that, make that finding. What does it mean for a social worker to exercise due diligence? Something I think we were talking about earlier. So asking the child, reviewing the file, if there was previous relatives who had popped up and said like, hey, I might be interested. Or even sometimes in the detention room, it's talking about like, maternal aunt came over and they were interviewed. Okay, is she interested in placement? Telephone, emailed, visited all identified relatives. Use the internet, use Facebook, use Instagram to make contact with relatives, because mom or dad might not know grandma's or the aunt's phone number, but they might know her Facebook account, they might know her Instagram, and you can like send a message to them. The department has all of those medias that they can reach out to relatives and even parents in order to communicate with them to get some way to go out and assess them. Yep.
Is there a case law discussion about these factors and sort of like what a level of effort that the social worker should be doing, or is it pretty much just the statute and these are the factors that we sort of use to argue with?
So the question was if there is case law that specifically addresses what is the level of due diligence the department needs to make in regards to finding them. There is no case law that I know of in regards to this issue, probably because it's not raised all that much. So who here, show of hands, knows what an ACL is? All right, that's you. Okay, so there's ACLs are all county letters. They are made by the Department of Social Services in California as their interpretation, according to case law, of the code sections and what they need to be doing to implement certain things. So there's ACLs on all kinds of different things, from non-minor dependent to what they need to do with relative placement and all that things. So they are not binding on the courts, they're not law, but they are what the Department of Social Services, which is the overarching agency of all of the county's agencies, believe should be happening on cases. And so the ACL talks about a non-inclusive list of things that they should be doing in order to exercise due diligence to seek out relatives. I would say anything you can creatively think of, put it out there. I like case law, that comes with doing writs and whatnot, and I think this would be a really great topic to have more definition of exactly what that means, because obviously with exercising due diligence, even when finding parents, I mean, when you read those, like, you know, did you check Facebook? Did you try the Instagram that like we've seen, like that we've used for evidence as to the parents' bad behavior? I mean, we're a very social media world at this point, so there's definitely ways and access. I will give you a colloquial story. I had a client who was 8 when they came into foster care. Dad was refusing to identify any relatives. I talked to my client, he gave me the name of an aunt and uncle who lived in, he said, not Vegas, but the one like Vegas, but not so great. And so I'm like, and they had unusual names, and I Googled them, found them. they were assessed for placement and he got placed with them out of state. You know, it's a little bit of effort sometimes and just like using the technology we have to find placements for kids or parents. What if the assessment pursuant to 361.3? Oh, here, whoa, okay. We're running out of time. Is not completed by the dispositional hearing. So it's specific in the code that indicates that it is not grounds to continue a dispositional hearing because of relative placement issues. But I would say, if your court will let you, go with it. The relative placement, the relative has the right to be assessed once they request placement, and it is a preferential consideration. I would recommend, if you have a pending relative, either for a waiver or whatnot, ask the court to immediately set a 361.3 hearing. Amount of time given will depend on what exactly the issue is. If there's a waiver and you know that they're like 2 weeks away from getting that waiver, I'd set the hearing in 2 weeks, ask for it to come back, and argue for the child to go home at that, go with the relative at that hearing. If it's like a more convoluted issue and whatnot, maybe you need more time on it. I'd say no more than 30 days, ask the court to set a 361.3 hearing. I don't know what's happening.
And they put you on hold.
We lost somebody.
Oh, then
Put us on hold.
whatever. If there's multiple relatives requesting preferential consideration, the social worker has an obligation to assess all relatives. A general practice tip. So if you've got like 10 relatives outside, try to figure out which one's gonna pass the quickest. As horrible as that sounds, the one that doesn't have any kind of criminal history, doesn't have any prior child welfare history, has a house that can actually take the kid. Even if that person's the temporary person for grandma who really wants the kid, who needs a waiver. That way the child's still with the family, still being able to access the family while you wait for grandma's waiver to get approved instead of the child sitting in foster care. But the department has an obligation to assess these relatives. Family reunification services is where we get into the weeds of relative placement. There is a split of authority as to whether relative placement preference or the duty to assess a relative under which 361.3 applies through reunification services. I will always argue that it does. It is imperative that the relatives who are interested let the court know as soon as possible, because some of the courts have been really looking at the fact that the relative came forward at the beginning and just weren't assessed for a really long time. I believe it also in the materials I gave is the JV 285. If you have a relative, have them fill out that form. It has a checkbox for I want placement with the child, and it can give them the edge to submit something to the court without it having to go through the social worker.
Right. So I'll try to summarize these quickly, but in terms of the top, to start off with In Re Isabella G, it's a 2016 case from the 4th District. So in that case, we have a minor who had 2 parents, unfortunately, who are suffering from some substance abuse issues. Mom's in and out of jail. This kid's living with paternal grandparents and parents. Eventually, the grandparents kick dad out, and they keep the child. So the paternal grandparents essentially raised this minor until she's about 23 months old, and then the parents come and say, that's my baby, take her, and a week later they're incarcerated, and now this kid's in foster care. So paternal grandparents requested placement. Paternal grandma had a few criminal hits, actually convictions that required waivers. And so they came up with a NERFM who was willing and able to take placement, which was great. And the parents would get reunification services. The issue is that the paternal grandparents' criminal waiver was never appropriately processed. So we get to the 21E, dad's TFR'd. We get to the 21F, mom's TFR'd. So now we're moving towards the 26 with adoption as a permanent plan with a non-related extended family member, with paternal grandparents who are having unmonitored visits every other weekend, visiting this kid, 3 days a week. So it's kind of a sad case. But anyway, the paternal grandparents file a 3D8, and the 3D8 is denied by the juvenile court because for 2 reasons. They say the grandparents failed to show best interest, and they failed to show that a change in placement is necessary. So the Court of Appeals reversed this order, denying the grandparents' motion to modify the previous placement and reverse dispo, and remanded the hearing to have a 361.3 for the paternal grandparents. And they do have placement, I believe, of the minor now. Yeah. So the Court of Appeals pointed out a few things. So the criminal waiver actually only took 3 weeks to go through once the department had a fire under them and they went through with it. So had they done their job from the beginning, before you had even gotten to jurisdiction disposition, this kid could have been placed with these paternal grandparents. So that was a huge issue. And even though the relatives filed a 388 to trigger an assessment under 361.3, the legal standard the court should be applying are the factors enumerated under 361.3, not the best interest, change circumstance. So just be aware that if a relative files a 388 on your case, I know it's happened to me, where they're requesting placement, it's triggering now a 361.3 hearing, and we need to be sure the court is actually applying the factors under 361.3 and not the standard 388. So takeaway is, again, and we're harping on this point, but you really need to focus on relative placement at detention, even in the event with a relative who has a criminal hit, right? Even if you get a placement with a NERF fund, that doesn't alleviate the department's duty to continue to assess that relative. And so even if no new placement is required, the relative preference still applies. They really should have applied throughout the life of this case. And in this case, they did apply it even after the termination of reunification services. So just make sure that you talk to your clients, you put on the record at detention, my client wants placement with this relative. They do require a criminal waiver. I want an update on that waiver at the next hearing date. And then at that date, you can ask for a 361.3, because at that point in time, the waiver, if you didn't set a no-time waiver, we're talking 6 weeks out from detention. That should have been sufficient time to process the criminal waiver. So we need to be on top of it. Now, in terms of INRI RT, it's a 2015 case from the 4th District. And in that case, it's a pause-tox baby, parents with a history of domestic violence and drug use, and another child who was in the system. So, well, you guys can read the case. I'm sorry, I'm going to have to speed ahead just on the takeaways. So, the Court of Appeals did reverse a lower court's decision not to grant a relative's 388 petition. And so that's, and they pointed out a few issues. The lower court, again, didn't adequately apply the 361.3 standards. They made a permanent placement with a NERF fund when there was a relative from the onset of the case who was available and ready to take on placement. And the lower court should have directed the agency to evaluate that relative for placement under 361.3. So in that case, there was bypass of reunification services, and so I think it's important to note that in INRI RT, this applied even though the parents didn't actually receive reunification services. With INRI Joseph T, this is the most persuasive because it's out of the 2nd District. It's a 2008 case, but it does say relative placement preference applies throughout reunification, regardless of whether a new placement is necessary or otherwise being considered. And not to get too much in the weeds, I know we're limited on time, but it's something that certainly post-disposition, at least in our in the 2nd District, we can say post-disposition, relative preference still applies while in reunification, right? So if you get pushback on that, certainly you could bring this case up. Jen already talked about what an ACL is. I'm glad that she did, and this is the one in particular, 1765, you'll see it referenced throughout the slides, that speaks to the department's obligation to assess relatives. It's good to look at as to their duty as well as their position. They do say in the event that another relative steps up and requests placement, that they're obligated to assess them, even if the minor's already placed with a relative. So it's just something that would be good to read through. It's not too lengthy, in order to hold the department accountable, and when they take a position contrary to what's in the ACL, if you point it out to them, I find that they're much more amenable then to do the assessment.
And now the cases where they're saying there is no relative placement post-dispo. So the most recent one is INRI MH. It's a 2018 case, not in our jurisdiction, is out of the 1st District. Where they basically said section 361.3 was not applicable for the case post-dispo and unless it required a new placement. So if the child's in a foster home and doing fine and they want to adopt, you don't apply relative preference. And in this case, the aunt who lived out of state literally called 2 days after the kid was detained asking for an ICPC for the kid to be placed with her. She was a foster parent in another state. MH, my argument always to the court is there's a lot of dicta in that case, and that's where the 361.3 arguments come in. That court basically found that 361.3 and 26K, the caregiver preference out of 26, did not apply, and then went off on like this tangent of dicta in regards to their assessment of 361.3. But overall, the overarching decision was that either way it was not in the best interest of the child to move, and that was the argument that they went with. NRA KL found that section 361.3 established a relative preference that applies in selecting a temporary placement when a child is removed from parental custody or when a new placement is necessary. It does not apply where the agency is seeking an adoptive placement for whom the court has selected a permanent plan of adoption. This is a real outlier case, so if anyone cites to it, they have to distinguish all over town. These kids were already in a permanent plan of legal guardianship. The guardianship failed. They then were trying to put them in adoptive home. Grandma, who knew about them being in the guardianship before, stepped up when they got placed in adoptive home because she was like, oh gosh, they're going to be adopted now, and was basically like, I want to be assessed for placement. They already had a permanent plan. They had already been through permanent planning services, and so it's a real outlier case. It's not something that you're normally going to see, so it's easy to distinguish from. Lauren R., the case I hate the most. This is the original case that kind of started this idea of you need a new placement in order to, requirement in order for relative placement to get re-triggered. So where adoption has been identified as the permanent plan, the relative preference under 361.3 did not apply because no new placement was necessary. So how they read it is that there's a comma in the actual code section, and they're saying that comma basically means that we are not going to consider any other relatives unless there's a new placement, which Joseph T. actually goes into a real distinct argument about like, Lauren R. read that completely wrong. That is not what that meant. The legislator was clearly trying to state it's not only at the beginning of the case when you're placing a child. If they need a new placement, you have to relook at relative placement is what the legislator was trying to say. Lauren R. court takes the complete opposite. They're basically saying you only look at relatives if there's new placement that needs to happen.
But isn't that only once the permanent plan has already been identified as adoption?
No, that is, the reading of Lauren R. is basically that unless there needs to be a new placement because the previous caregiver gave up this child or got removed from the child, relative placement is not triggered. And I really don't like this case.
Did you say what district Lauren R. was from?
Lauren R. is also from the 1st district, the same as MH. Is reserved family approval required for placement with a relative or non-related extended family member post-dispo? No. Emergency placement findings under 361.4 or 361.45 allows for emergency placement post-disposition. There's an FYI, which is a DCFS policy as opposed to an ACL. So LA County specific that relates to that issue. This is all in your slides. They also can place for a compelling reason based on like the special needs of either the child or the specific requirements of the caregiver. I'm going to just skip this. Resource family approval, RFA, the joy of the world. There's two, so for the old school people, there was AFSA and there was a home study. AFSA was the federal law that determined what a safe home was for placement. RFA is basically a two-part assessment where they have the background home assessment, which has like the criminal background check, the khaki check, the physical assessment of the home, and then there's the psychosocial assessment, which is like a home study. Do we have time?
Yeah.
Okay. And if you have more questions, feel free to call or email. I believe our info is on the slide. We were gonna do a
quiz, but we don't have time.
Oh,
Thank
and
you.
I see my kid.
And you guys might have noticed that page 6 was not in the packet. I'll make sure that the complete slideshow is sent to everyone in the firm.